Hello and welcome back. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on estate planning, trusts, legacy, property, and everything else on my clients' minds. In this episode, we're going to talk about another difficult subject, creditors. We're talking about a situation when a creditor has a claim against a person. Let's use the hypothetical of a child. That helps to clarify who we're talking about. But we could be talking about a spouse or a partner or a friend or a more distant relative. Any situation where a creditor has a claim against that person. So this could apply all throughout the estate plan. Think about this. When assets are left to a spouse, those assets could be subject to the claims of that spouse's creditors. So as we're talking about these issues, as I use the example of the child, you could just insert whatever beneficiary you might have in mind. So we're talking about creditors with these kinds of claims. That creditor's claim might be based on a business. Maybe the child signed a guarantee for a business loan. If the business fails, then the creditor would seek to go after the child's own assets. Or maybe that claim is based on an accident. Maybe someone slipped and fell in the child's home. Or maybe the child was in a car accident and someone was injured and now has a claim against the child. You might think or hope that insurance would cover some of those claims related to an accident. But keep in mind, the insurance might not apply, or the insurance might not cover the entire claim of that creditor. You could also think about a divorcing spouse as a kind of creditor seeking to go after the child's assets. Let's also take a moment and think about predators, another difficult subject. These are people who would want to take advantage of the child. If that's a concern, then there are other considerations here of how to structure gifts, maybe especially the desire to keep the terms and assets of the gift private, and maybe even have another trustee involved who can protect the child from himself or herself. So keep that issue of predators in the back of your mind. That's an important consideration too. And I don't bring all this up to scare you, but I find that these issues are really important to our clients. Estate tax is less of a concern to a lot of clients because of how high the estate exemption currently is. But I find that issues of asset protection are still a key concern for our clients. And I get it. Let's face it. We're in a litigious society. Claims could come from almost anywhere. It also makes sense that we would talk so much about asset protection in this estate planning context. In many ways, asset protection is a central feature of estate planning. So think about it. The estate plan is about transferring assets and setting up structures that will hopefully ensure that the assets are used for the intended purposes. And taxes can obviously interfere with that. Or substance abuse. Think about my recent episode on substance abuse concerns. But also think about creditors. If a person receives funds and a creditor seizes them, that obviously frustrates the intent of the estate plan. So let's think about the default rules of how all this operates. Again, let's use our hypothetical example of the child. If the child has a creditor, then the creditor could seize the child's assets. There are ways the creditor could just require that the child's investments or the child's cash be distributed to the creditor in satisfaction of the claim. But here's the important point. If the assets are held in a trust for the benefit of the child, or again, for the benefit of this other beneficiary you might have in mind, then very different rules apply. This is based on a concept called a spendthrift trust. It's a unique feature of American law. If the trust has specific language in it, then the creditors of the child typically cannot reach the assets. In some states, this protection is almost automatic. In other states, the trust has to have specific language or terms for this to apply. In fact, in many states, the child can even be a trustee or the sole trustee of the trust, and the trust would still have these protections from the child's creditors. Spendthrift trust law is very clear. The creditor cannot compel distributions to the child, and the creditor cannot require that distributions be made to the creditor. In a sense, the creditor just has to wait until the assets are distributed to the child, and then the creditor has to pursue the child. Now, all this is going to be based on the governing law of the trust and the terms of the trust. And based on that governing law, there are typically some exceptions, even if spendthrift protection applies. In many states, child support creditors can go after the assets of the trust if the child is a beneficiary and the child owes child support. In some states, a divorcing spouse could go after the trust for overdue alimony or spousal support payments. And as in many cases, the IRS just has to play by different or gets to play by different rules in these situations where the IRS has a claim against the child for back federal taxes. But let's leave those exceptions aside for a moment. You can see how this spendthrift protection provides real substantial protection for the trust assets against the claims of the child, this beneficiary we have in mind. So of course, there are some costs of having assets in a trust. I've spoken about those in other episodes. One cost is the fees of filing an income tax return for the trust each year. And there might be some additional income tax due on the trust because of the marginal rates for irrevocable trusts. Again, I talk about that in my episode on income taxation of trusts. But again, we can think about the advantages of having the assets left in trust versus those potential costs. There are two important clarifications here. These come up a lot. First, the only real time that this kind of trust can be set up is at the time of the gift. Maybe it's a lifetime gift or a gift that you would make upon your passing. If the assets pass outright to the child, then there are very limited options of how the child can still protect the assets from the child's own creditors. That'll have to be the subject of another episode, how the child or how you yourself could protect the assets from, your own creditors. And then second, importantly, I'm talking about an irrevocable trust for the benefit of the child. Some clients ask if they can use a revocable trust or if they can just add this gift to the child's existing revocable trust. The answer is no. If the child can withdraw the assets from the trust for any purpose, or if the child can revoke that trust, then the child is treated like the owner of those assets. And so the creditor can treat the child like the owner too. So that is, if the trust for the child is revocable by the child, then the trust likely doesn't have any of this same creditor protection for the child's creditors. So consider this. When making a gift, think about whether to leave the assets outright or in a trust. And then when structuring the trust, consider how long the trust will last. Some clients like the idea of assets coming out of the trust, maybe at certain ages or fractions over the child's lifetime. But if the assets must come out of the trust, then once they are received by the child, they are then subject to the claims of the child's creditors. But how about when administering the trust? Think about this issue too. Consider transactions with the trust. In one episode, we talked about how the trust assets can be used to help a beneficiary purchase a home. But remember, if the assets go outright to the child, and then the child uses the assets to buy the home, then those assets, that home, is now in the child's name and can be subject to the claims of the child's creditors. In that other episode, we talked about an alternative of maybe purchasing the home within the trust, where it would have that protection from the child's creditors. Also, when administering the trust, consider how distributions to the child over time can have an effect on this creditor protection. Some trustees like to transfer the income to the child each year. They think this might save income tax because of the different marginal rates for a trust. Again, I talk about that in my episode on income taxation of trusts. But consider too that when assets come out of the trust, they lose that creditor protection. So even relatively small distributions over time can pass a lot of assets out of this protected trust and into the child's name. And also when administering the trust, look ahead a little bit. What state's law applies to the trust? You might consider, are there any reasons to move the trust to another state and have that other state's law apply where there might be more protections from the child's creditors? That's obviously a very complicated issue of whether and how to move a trust from one state to another. So we've talked about a lot in this episode, and as always, I like to leave you with some thoughts for further consideration. So here are just a couple questions. Number one, how important is this kind of protection for you? Or put differently, how important would it be for you to give this kind of protection to your beneficiary, to your child or grandchild or surviving spouse? Think too about that beneficiary, that child or surviving spouse or the like. Are they in a profession or situation where they might likely have these kinds of creditors? You might want to even ask them if they would appreciate having this kind of protection in the event of a gift or upon your death. And then let's think about the structure too. Again, some clients like the idea of the child or other beneficiary taking real ownership of the assets at some point or at a certain age. Actually, we talk about that a lot on this podcast, is how to structure the trust in a way to really facilitate the child being productive and independent. But again, as we were talking about here, if the assets go outright to the child, maybe it frustrates that creditor protection that might otherwise be available. So instead of the assets coming out of the trust at some age, maybe pursue a different structure. Maybe the assets could stay in trust where they could be protected from creditors, but maybe you could allow the child to become co-trustee at some age, or sole trustee, where they might have that discretion over the trust assets, and yet they would likely still have this protection from their creditors. So as in many instances of what we talked about in this podcast, I guess the takeaway is look before you leap, or that is, look before you gift. I'm Steve Murphy, and this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.